Coming up on Chopper's Political Podcast.
I wouldn't have wanted my mother thinking, well, I'm dying now and I better go quickly because that's what the family may want.
Welcome back to Chopper's Political Podcast with me, Christopher Hope, GB News' political editor. Weekly, I give you the best guest gossip and stories from our studio in the bowels of Westminster. It's been billed as one of the biggest challenges and changes in social policy since abortion was legalised in the country. On Friday this week, MPs will vote on whether to legalise assisted dying when the debate on the terminally ill end-of-life bill takes place, a private member's bill. There have been strong opinions, and by my count, as many as half of all MPs are yet to declare how they're going to vote in what will be a free vote, a genuine knife-edge, unknown decision in the Commons. So, ahead of that, we'll be hearing from a Labour MP and a Tory MP on different sides of the debate. Later, we'll be hearing from Sir Bernard Jenkin, the senior Conservative backbencher, a Tory grandee, who is still to make up his mind. But first, we have Jake Richards, the new Labour MP for Rother Valley, who's put his name to the plans. Jake Richards, welcome to Chopper's Political Podcast.
Good to be here.
Great to hear you in the bowels of our studio.
Yeah.
Before we start, I've got to give you your present from GB News. It's a free mug.
I get to take this home, do I?
Yeah, you do.
Wow,
yeah, make sure.
I'm honoured. Thank you.
Because you're a very political family. Your dad, Steve, is a very famous journalist, so I know, and of course.
Yeah, well, he's got a collection of mugs, and now I can add my GB News one.
Exactly.
To,
political mugs is what many people collect, I think, in politics. Why does the law, though, need changing on this? It's a very, very contentious, difficult area for many people. Why are we in this place so early in a Labour government?
Well, the first thing to start with is that the current law is a mess. So we have a criminal law which essentially, does criminalise anyone who assists a loved one at the end of their life to end their life. It's a criminal sanction.
On that, there's guidance saying,
that's
which was drawn up by Keir Starmer when he's DPP, don't forget.
So just to get a bit technical for your audience, but yes, so the law, 1961 Suicide Act, criminalises everyone to assist, who assists anyone to end their own life. The Supreme Court essentially said that, urged the Director of Public Prosecutions to issue guidance as to when and why they would prosecute and when they wouldn't. At that point, Keir Starmer was Director of Public Prosecution. He issued guidance which essentially said, which I think most people would accept, we should show real leniency and compassion to loved ones who do this out of goodwill.
But you couldn't guarantee no prosecution, is the point.
You can't guarantee no prosecutions because the law wouldn't allow him to do it. So there's a mess. So the law says you can't do it. The guidance essentially, to speak in a very flippant manner, which is probably inappropriate, but kind of gives a nod and a wink and says, look, if you're helping a loved one, then we're probably not going to prosecute you.
But we can't give you that guarantee.
And you have to investigate every potential offence.
So you face a police investigation if it happens.
And it's worth noting that 4 former Director of Public Prosecutions, and that's not including the Prime Minister, have all come out and supported this because they see this as a completely unsustainable, not fit for purpose legal provision. So look, it's not fit for purpose in kind of a dry, technical, legal sense, but then also the human sense. You know, hundreds of people, thousands of people, we can always try and put numbers on it, in my view, are dying in agony and pain unnecessarily. And if we're able to deal with that safely, and that's a big if, then I think we have a moral imperative to do so. Right,
an important issue, and an issue which maybe a government can consider in its early years before an election. So it's a moral issue for all of Parliament. Is this the right vehicle to do it? A private member's bill tabled by Kim Leadbeater means that the government will not produce any impact assessment on the impact on public services to make this happen, on judges to sign off on the plans and GPs to do so too. Is that right?
Well, a private member's bill is really the only vehicle for this kind of social change. It's the same for the Abortion Act, the death penalty, the divorce laws. This is the vehicle we have, and there's a reason for that, which is that no party is going to put this change in their manifesto because, understandably and rightly, it's not a political issue. It's not whether you're right wing or left wing. It's a personal moral issue, and so you couldn't hold a party together. So the only really vehicle in our constitution is a private member's bill. Now, I accept that, you know, ideally you'd have all that information nicely put together in tables for journalists to pore over. But I think it's slightly disingenuous to say that information is not already there, because we have 300 million people around the world who have access to some form of assisted dying.
Yes.
We've had various select committee reports. We've had research into this. So I kind of find this argument slightly, as those who oppose kind of trying to find a way to oppose it again.
Nitpicking.
Well, it's worth noting, if I may, just in 2015, when this last was before Parliament, you know, this issue about whether a private member's bill was appropriate was not raised once. And now, 10 years later, I get the sense they're losing the argument on the change.
So looking at process.
They're clutching at straws. And I mean that respectfully, because I do appreciate people who disagree with me on this, and I respect their view.
And just how would it work? So if I wanted to go through this process, how would I kill myself?
Well, the bill provides for, firstly, you have to be an adult. Secondly, you have to have mental capacity, which is really important. So lots of people wouldn't be able to be covered by this. 2 doctors would have to give a prognosis that you have less than 6 months to live, and that you have capacity, and that you've made this decision without coercion. Then you would go to a High Court judge. A judge would look over that information, a signed declaration that you would have done. And then after that, there's a 14-day what's called cooling off period, and then you would again have to sign a declaration
at the end of that.
And at the end of that,
so it makes you sign something again to reassert.
Then you are given, essentially, again, to use flippant language, the tools to end your own life, and it is self-administration.
You're given a pill and you take it yourself.
Yes, and it's worth noting that in other jurisdictions where they have a similar mechanism, around a third of people never use it. But it's about having that control. And when I speak to family members and those who have...
So a third are given a tool to do it.
Are given the pill, they've gone through the whole process, and then they go home and then they die, hopefully peaceful deaths, without having to use it. But when I speak to people who are facing terminal illnesses, I've spoken to Esther Ranson, but many others as well. This is not just about Esther Ranson. There are thousands of people.
That's where it came from, isn't it? And the critics say it came from a commitment to Esther Ranson. Sadly, he's got terminal cancer. No one negates what she's going through.
I don't accept this, because this has been a campaign by either family members of those who've had really
difficult
difficult
deaths. But she spoke to Keir Starmer, is the point.
She has been a figurehead for it, but as you know better than me, you've been around a long while. When you have political campaigns, they can be grassroots campaigns, but you need a figurehead, and she's a very powerful figurehead. But just to be very clear, the 30% of people who never use it, they get a real solace in being in control. And for me, this is what it's about. I come into politics not to be too pious about this, but to try and empower people in lots of different contexts. And I think actually people approaching the end of their life, some of the most vulnerable people, if we can empower them safely, then we should. And I'm reassured that the safeguards mitigate the risks here.
Safeguards like if the judges make mistakes, no right of appeal for families. I'm reading through issues in one of the newspapers today about this, the concerns, of course, we should be talking about ahead of the debate. So they're saying no right of appeal for families, judges can make mistakes. Terminal illness can include mental health, although it shouldn't in terms of the law. If it says there that if you are 6 months from death, that would go above maybe the issue of mental health. Anyway, there are some areas. Again, these can be hammered out, can't they?
Well, I think, look, I have some sympathy to the first part of the
right of appeal.
Yeah, and some of the judicial process and what that actually looks like, and some of the rules of court. Again, to be a bit technical, how this court hearing is going to take place, whether there can be third-party applications. I mean, I'm a lawyer, so this kind of stuff interests me. And I've read a lot of the legal commentary for people who oppose this, and I'm sympathetic to some of the issues they raise. I don't think they're insurmountable, and they can be dealt with in committee. And another really important point about this is if this bill is passed, if it receives royal assent, it's likely to be in the spring or even the summer of next year. And then even then, it's going to be implemented over a 2-year period. So, I think I'm not trying to say that, let's sort out the details later, but we do need to get this principle over the line, and that's what second reading is about, and that's happening on Friday.
The issue of coercive control is known about, and then you have, of course, pressure put to bear on a mum or a dad or a spouse or whatever it might be to end it now, and then obviously they have an estate and it goes to family, or it could be just a coercive control situation, which is dreadful for people. What are the protections on that?
So I think that's the best argument against is coercive control or coercion in general. I actually think I'm less worried about the kind of evil family member trying to get their estate, because I think if you've got 2 doctors and a judge looking at this case, and by the way, it's not like coercion doesn't happen at the moment.
No.
And this is an important point, actually. I mean, coercion happens at the moment all the time, and we know that people perhaps don't go into a care home because they want to save money for their son or daughter who's kind of persuading them, or don't take treatment because they think they'll be a burden, or the hundreds of people who kill themselves at the moment at the end of their life because they want to end it all in horrible circumstances often. And we only investigate coercion once they're dead, which is no good. This bill would actually bring that inquiry before death, which is both rational and humane. I think the better argument from those that oppose it is that simply crossing this Rubicon, changing the law, sends a signal to wider society that it is okay to, and again, I use flippant language,
it's okay
to sort of give up. And that does weigh heavily on me. You know, that Parliament is sending a signal to the country that actually, if you're a burden, if you're now, my view on this, and I've thought about it a lot, is that we have a responsibility to ensure that doesn't happen if this bill passes. But actually, if this was ever going to sort of widen the scope to vulnerable people, those with disabilities, those with mental health issues, you know, I find that so abhorrent that I think something broader would have had to have happened to have changed our social and political context, rather than this bill be the catalyst for it. I hope that makes sense. But essentially, I think, you know, yes, it's a concern, but I think we as a country are better than that.
Wes Streeting has made his views known against the plans. He's the health secretary. He worries that failures in the state offering good palliative care to people towards the end of their lives might mean they feel they have to kill themselves. So he thinks it's not. He thinks that the decisions are informed by bad failures by the state, and he wants to improve palliative care and thinks that might need killing yourself less likely. Is that a good argument? Yeah,
well, I think we need to improve palliative care, but I don't think it's either or.
No.
Now, I think there could be something in this bill, perhaps coming later down the line, which puts a legal responsibility on NHS trusts for anyone who even begins going down this road to make sure that they have the full suite of palliative care options. Because at the moment, one of the big problems with palliative care is that there's a postcode lottery. If you're in one part of the country, you might get the best palliative care, and if you happen to be in another part, you don't. 100,000 people a year, Hospice UK say, die without appropriate palliative care. So I see this as a kind of an opportunity to improve palliative care as well. And
from the patient upwards. I mean, that's always the point in policy, is put the patient first.
Yes, exactly.
And if you empower them to force care to come to them in the way you're describing, is that possible then? They might try and... have you heard that from inside the government?
No, look, I mean, this is just an idea I've had. I'm a mere backbencher.
No, stop it, Jake.
But, you know, so... but I think that's something that we could perhaps look at. But I don't see it as an either or. And actually, you know, and Kim's been really good about this. We're talking about death. We never talk about death. We're very British about it. We don't sort of talk about it, and we're all talking about it, which is really good. And part of that conversation has to be about palliative care and improving it. So to coin a phrase, you know, a national mission to improve palliative care as a result of this change, I think would be welcome. And I just touched upon it before. We're probably around 3 years before this would ever actually come into being enacted. So we've got 3 years to use this as an opportunity.
24 billion quid and raise in the budget on NHS.
Well, an Labour government always properly invest in the NHS. You know that, as opposed to our political opponents.
Let's move on from that. We're not. That's not today's podcast.
It's not appropriate for a political attack, perhaps. But
yeah, I mean, and I've been with Keir Starmer a lot recently. We asked him twice over the past 2 weeks how he'll vote. He won't tell us, but he will vote. He will vote.
Yes.
On Friday, but won't tell us. Have you heard much more from him? Has he talked to you about this?
He hasn't divulged that to me. No, but I mean, you can look back. I was reading the debate in 2015, and I'm not sure how many journalists have done that, but it's worth reading again. And
he's pretty clear.
He played a very key role in that debate because he was going through in a neutral way. He made it clear he wanted to be neutral. What the process was as to the Director of Public Prosecutions and how he.
Are the safeguards the same as they were in 15, the last time Parliament voted?
It's not dissimilar, but they're more robust now.
So what were they then? So it's tightened up since then?
Yeah, well, I believe that the judicial function is an added oversight from what was, I think it was Rob Maris.
On that, do you worry about whether it could be a rubber stamping exercise? I mean, I was reading today about some judges concerned about lack of time to consider properly what they're looking at, and given the importance, you know, you may. And there's a remark here. I think James Munby, who's a former.
Yeah, I've read his piece.
Yeah, he says even high court judges are fallible and make mistakes.
Yeah, I think there are legitimate questions about what we're asking the judge to do, but. You know, and judges do make mistakes. I've been in court and judges have made mistakes.
But this is the biggest mistake to make.
But this is just another safeguard. You know, you have two doctors. And look, ultimately, in life, like in everything, you cannot mitigate risks completely. There will always be evil people out there, but you have to build a system which both gives the benefit, in my mind, to help those who are suffering unimaginable circumstances at the end of life while mitigating that risk as much as possible. I think this bill strikes that balance. There are some details to work out in terms of what the judge is being asked to do and how they're being asked to do it. But that, for me, is not necessary for primary legislation.
It's very tight, the vote on Friday. This
Yeah.
podcast comes out on the evening of Thursday before the vote takes place. What do you make to that? I mean, if it's a narrow win, I mean, for example, if only a minority of MPs vote it through, which is possible because of the scale of the abstentions, you may have 250 MPs against 200 against, and then balance
52-48.
Yes, but the point is, if only a minority of the Commons votes for it, what does that mean? It means the Parliament isn't really decided, and it means also the House of Lords may take a dim view on it and try and frustrate it.
Yeah, all those things are possible. I mean, I'm sorry to say, let's wait and see what happens. I think there is still, let's see what happens. I think it will be close as it happens. Having speaking to colleagues, I would just add for your listeners, I've spoken to colleagues, Labour, Tory, Lib Dem, and Reform about this. And Greens,
they're all divided.
And people are taking it very seriously. They are. People. It's a profound issue.
When people talk about it and think about it, and I'm thinking about a lot more having talked to you on this podcast about it. It is really visceral. It goes to the very heart of being a human. Yeah, and what we're talking about.
And there are some really good arguments on both sides. And I genuinely, one of my best friends in Parliament is sort of working on the opposite issue, and we're still best friends, and we can still chat about it and talk about it. So look, I respect those who disagree. I think it's going to be close. And let's see what happens.
Okay. And just very finally, if it doesn't pass tomorrow, or it falls at the first hurdle, or second reading in the House of Commons on Friday, then what? It comes back into Parliament, or it's just settled here for this Parliament at least?
No, I mean, who knows? Private members' ballots are every year. I think a lot will depend on that in terms of the result. I mean, if it's close the other way, for example, then if someone comes back a year later, or whether the government says, well, this hasn't been passed, but it's clearly an issue that needs to be looked at, we're going to do something about that and come back in a couple of years. I don't know. I don't think this issue is going away, and partly that's informed by the public. You can look at the polling, and I don't think polling is an attractive argument on this, but you look at the polling, and clearly a lot of people are in favour of changing the law in this area. So I don't think
Are they
Parliament...
informed, though? That's a question.
Well, no, I agree, and that's why I personally don't use polling as kind of a key part of the argument, because I don't think it's particularly helpful. And also, there are things, we don't. It's not a referendum. We're not delegates. We're here to make up our own minds. But it's clear that there is a wealth of concern about our end of life laws in this country and how we treat people, and we need to do something about it.
And this amendment, which could scupper it all by having a review, a commission of some sort into it. You're pulling a face there for listeners who can't see.
I mean, I'm pulling a face because I respect colleagues who've put their name to that amendment. I know some of them very well, but we have to have this debate, and that amendment, if passed, would stop the debate. And I think the public would look pretty dimly on that. After all this, we have a vote which says actually no debate. It has no force. The amendment on the government. It would simply stop it there and then, and it would be a great shame.
And Jake Richards, finally, I mean, is this what you came into power to do, into government, into being an MP? Is this quite interesting? I mean, it's not what you thought you'd be doing, I guess, within 5 months of being made an MP, but it's what...
No, but look, it's not... To be honest, it is one of the issues that I wanted to try and pursue if I was lucky enough to become a parliamentarian, because I think it's that important. I've had personal experience. I don't really talk about it that much, but...
Can you say now?
Well, just family members who've had difficult deaths. I wouldn't put it any higher than that, and it's something that... And as I touched upon earlier, I come into politics to try and empower people in lots of different contexts, as I say, and this one seems to be actually the most acute. People right at the end of their life who are desperate to end the agony and pain that they're suffering. And I hope that this legislation can do that.
Well, Jake Richards, Labour MP for Rother Valley, thank you for a very thoughtful and incisive chat here on Chopper's Political Podcast. Thank you.
Thank you.
Now, Jake knows how he's going to vote in Friday's debate on assisted dying. Less sure is my next guest, Tory MP Sir Bernard Jenkin, a Conservative grandee and chair of the Standing Orders Committee in the House of Commons. Sir Bernard, welcome to Chopper's Political Podcast. Great to have you on.
Thank you.
Very, very important issue. We had the issue set out to us by Jake Richards. Where are you at the moment on this?
Well, my starting point has already been, well, of course, people should have a choice. And
that's a Conservative way, isn't it?
Why would the state want to stand in the way of people having that choice? And I remember very powerfully being lobbied by a vet in my constituency who said so often people come along. I mean, this is not comparable, obviously.
I know what you're saying.
But come along and have their dog put down or their cat put down. And they look at him and then say, why can't we deal with people in the same way?
Yes.
And there's something very obvious and just about that. but this is something very, very different, and that not only is the devil in the detail, but it is a threshold decision. This about
By which you mean?
It's a watershed, isn't it? If we agree to this, we are agreeing a principle, and the principle is very, very clear that giving someone a humane death, as opposed to managing a humane death as humanely as possible, but assisting someone to end their own life, is a very, very big threshold.
It's a Rubicon to cross.
A Rubicon. And then, all the conditions and the protections, they're ancillary. They're not about the principle. And the evidence is from other jurisdictions, and some people dispute this, of course, that these other boundaries get shifted or moved or practiced the way they're
corners are cut, are you saying?
I'm not saying corners are cut. I don't think anyone's cutting corners. I think there are, but as we get used to this principle, we will treat it differently. It will change the chemistry. It will change the whole atmosphere about how we approach death and long-term illness. And
it might mean that you won't suffer in pain. It may be a positive thing, you see.
I totally accept that, but it may create different kind of suffering. That it may create. We talk about. I mean, the probability of coercion is one, in my view, but that's not necessarily a knockout argument.
That's a spouse or a son or a daughter pressuring someone to end their lives. We live in
a country where granny dumping, for example, is a phenomenon, and
meaning into an old people's home.
You dump your elderly relative into an old people's home and forget about them, and it's astonishing how many people are in old people's homes and they're never visited by their families. But if there was a possibility that by encouraging that person to shorten their lives, they would save the family money, that's I think where the risk of coercion comes in. And coercion, we think of well, that would be very obvious, but I mean, we've all occasionally suffered coercive relationships with colleagues or whatever.
You feel pressured.
And sometimes the coercion is very subliminal, very subtle, and indeed protecting people from coercive relationships in family relationships is a very new branch of the law. So there are a lot. That's just one of the grey areas. But what I'm also concerned about is that I wouldn't have wanted my mother thinking, well, I'm dying now, and I better go quickly because that's what the family may want. And I never discussed death with my mother. I was by her bedside for a great deal of the time, but she might have thought that and not expressed it, and moved down a track which she felt we all wanted without ever discussing it with us. I can imagine that.
Yes.
And it's about self-coercion that we should be equally worried about. Presenting a dying person with a dilemma they don't currently have to deal with. It's a different kind of suffering. And life
is so precious at the end of life. I lost my dad in April, and even when you have just a bit of him is still there with that familiar smile, there's a value there, you see, which I think.
Well, my dad said
would weigh on me
a few days before he died, the physician asked, well, how are you feeling? And he said, not 100%.
Yes.
With a bit of twinkle in his eye.
Yes. Patrick Jenkin, of course, counting this too. I knew, actually. Yes. I knew your father, of course. You're a senior person on procedure in the House of Commons. You sit on you're running the SI, standard statutory instruments, which are measures which go through on the nod in the Commons, and you work out what should do that, go through that way. Why is this a private member's bill? And that matters because it means there's not a proper assessment by the government on its impact before you vote.
The comparable bill would be the 1967 Abortion Act, which was also a private member's bill, which was also a threshold act. And in those days, the opportunities for guillotining and curtailing debate were very much less in the House of Commons than is practiced
So you
now.
could talk and talk and talk in those days.
Well, on a private member's bill, in theory, you can talk and talk and talk. But on a private member's bill, what tends to happen is the sponsor of the bill decides who's on the committee stage of the bill. So I'm sure Kim, who is approaching this incredibly seriously,
It's Kim Leadbeater, of course, the sponsor.
She will not wish to stack it with proponents. She will want to have a proper debating committee. There will be opponents and proponents of the bill on that. But it is quite time limited. And of course, these days, every government bill has to say it's compliant with the Human Rights Act and there's an impact assessment.
And that's not happening with this case.
That doesn't happen with this bill.
I find that interesting and
worrying,
I would argue.
A private member just doesn't have the resources or the capacity.
No, but why isn't the government taking it over? I know you go back to 67 and the Abortion Act. Shouldn't the government say, well, this is so important, we need to give MPs full facts before they vote? Instead, it strikes me MPs are voting blind to some degree on the impact of this bill.
Much water will pass under the bridge if this bill gets through its second reading. So, I mean, the traditional view is on a second reading you're voting on the principle of the bill. How well or badly the bill is written might affect people's perception of whether the principle should be approved or not. And there are some gaps in the bill. We had a former Lord Chief Justice on the Today programme earlier this week explaining that how a judge is presented with the evidence is simply not, it's just a completely blank space. Now, some people in the family courts would say, oh, well, there are ways of doing this and this is how it's done. But, does the person need legal representation? How are their views represented?
There's no appeal for families. Sir James Munby, who ran the family division in the High Court, he says even High Court judges are fallible and make mistakes. So procedure is very important. Procedure
is very important, and also concern has been raised about the effect on the judges handling these cases, because the kind of cases, should we switch off the life support or not, they take a terrible toll on the individuals who have to adjudicate those cases. Is that going to be the case in all these cases, or are we going to have a cadre of a few judges who become sort of immune to this kind of decision?
Yes.
It's a very sensitive comparator. Again, the Abortion Act 67. At the time it was debated, you would never believe that it was intended to provide the simple right to choose for women that it provides. Personally, I think that's right, but if you read the Act, that's not what it says.
It's never been challenged, though, that Act, has it?
No,
and in fact, that the terms have been moved about, I think. Is that right?
Well,
I don't remember that.
I mean, I know enough. I've read the Act, and I talked to a human rights lawyer about it earlier this week, who's in favour of the bill, and she just said, "Oh, it's not my field. I don't understand. I'm not the expert on this." But you could see what I meant. That this rather glib term, the slippery slope argument, it's definitely a concern. The difficulty in this debate for a member, someone who doesn't major on this kind of issue, is you're besieged by colleagues who are in favour or against. You're besieged. I mean, I've never had so much advice on a bill come through the post and email. Really,
from MPs or from experts?
From experts, from both sides of the argument. And you never know quite what's being said for effect and how true anything is. The library brief is very good, but very extensive.
That's the House of Commons
library. But they
have
to be very neutral.
Yes.
And, in the end, you're left making your own judgment.
You seem quite anguished about that. I'm not surprised.
Well, I find a lot of members are very anguished about this, but not just new members.
Yeah.
I walked across from the chamber to Portcullis House last week with a well-established Labour member.
That's in the Commons.
In the Commons, and she was deeply unhappy about the difficulty of the decision being. And we had one of those sort of sharing moments
across the divide,
where we understood each other. And I hope people on both sides of the argument will respect doubt, because I think doubt is a very
and doubt means don't vote for it, don't vote either way, sit out the vote. What happens if?
Well, I think what I'd be inclined to say, if you're in doubt, then you probably have to vote against, because once this has been passed, there will be no going back. There's no jurisdiction that's reversed this.
It may fail at third reading after a lot of chat about it, and the Lords may reject it.
I've only ever heard of one bill failing at third reading, and that was the Sunday Trading Bill in 1980 something. A very, very odd circumstance. It was a government bill, but third reading is not usually an event.
The Lords could kick up if, for example, let's game out what may happen. If 280 MPs vote in favour, 220 against, the balance abstain, you've got a minority of MPs voting for it in the House, haven't you? Lords may look at that and go, well, there's not a clear view here, Parliament or the House of Commons. We need to be a bit careful with this legislation.
Well, the Lords produced the last bill, which was the Charles Faulkner bill. And were in favour and passed it through all its stages and sent it to the House of Commons. I would be surprised if the House of Lords doesn't accept what the House of Commons decides.
Even if it's a narrow win?
They may well have a go at the detail, and of course they do scrutiny of legislation very much more thoroughly than we do in the Commons.
Yes.
And with a lot of expertise on that.
Yes, a lot of expertise.
The advantage of an appointed House, incidentally.
Correct, which judges, and of course your father was in the House of Lords. Your father retired, didn't he? Was the first to retire, I think.
That's right, he was, yes.
From memory.
I remember you interviewed him at the time.
So I did for the Telegraph. You mentioned new MPs. You're not a new MP. How many times have you voted on this in your time in the Parliament?
Only once. 2015, yeah. And I sat through the debate then. And just as an indicator, I really thought I was going to vote for it until I'd sat through the debate.
And that's your plan this time?
And by the end of the debate, I thought, I can't vote for this.
So you voted against?
I voted against.
And your plan this time is to sit through it again and decide again?
Yeah,
even though you know the arguments, Bernard Jenkin.
Well, the arguments have shifted. The medical profession has shifted a long way.
In favour? What do you mean? Or
they've shifted a long way in favour. There are still many in the medical profession against it. There are different polls. Apparently the majority of palliative care specialists are against. But I think there's much more realism that we've got to grapple with this as a question, because we now have so much control about whether people live or die, or when people live or die. One of the more persuasive arguments I've heard is that if what you're providing to a patient in terms of palliative care is so overwhelming it shortens their life, that's fine. And I can imagine, when, one wants one's loved one to be on as much morphine as they need. And if that shortens their life, that's fine, because your intention is not to kill the patient.
To ease their pain. Ease their
pain, yes. But if it shortens their life, that's a byproduct of easing their pain. It's not the intention. But if you are administering a substance in order to end their life, that is a completely different thing. But so the GMC would say you can already give as much palliative care.
It's just not officially done, is it?
Well, I think we need more open conversation about that. Perhaps it's okay for the patient to have too much morphine. It's okay. That's not inhumane, and it's nowhere near assisted suicide. It is just easing their path.
The problem now, of course, is if you help someone kill themselves by going to a clinic overseas, you have to have a police investigation. Now, the advice is normally not to prosecute, but you have to go through that trauma of the difficulty of being questioned by the police about it.
Well, you do and you don't. The DPP under Keir Starmer made it clear that they weren't really interested in prosecuting these sort of cases. But it is technically, what the authorities have to be clear is it in the public interest to prosecute this case? And frankly, if people want to travel abroad to avail themselves of a service that's not available here. But that's another question.
It's costly, isn't it?
Well, how much is all this going to cost the NHS? Because I'm told the intention is this should all be done by the NHS. It should be available on NHS wards, that you can choose to shorten your life, and or shorten your death, as the proponents call it. I want to be completely fair here.
Yes, language matters.
But how is that going to affect the national health? How is it? We don't have the impact
maybe
statement of
when
that.
Wes Streeting, we know, is against it. He said so as an MP. Of course,
And he voted for it before, didn't he?
He's also health secretary. I don't know how he voted before.
No, I'm not sure.
His view is that the palliative care, needs to be improved to give everyone a fair choice, because of course there's also a postcode lottery, as you'll know as an MP, between different places you can live in the country where it's better quality care than elsewhere.
Well, that's a different subject. But we should want more innovation in the health service. And
Yes.
if we finish up with different kinds of care in different parts of the country, that should be.
But
a
that
good
can
thing.
affect choices, you see.
But it does. It does.
David Cameron has said in the Times on Thursday he is now in favour of this. Do you have a view on that? Will that move the market for some MPs?
It might. I think people will make up their own minds.
Yeah.
I confess I haven't had a chance to look at his article and see his reasoning for changing his mind. But I mean, I think the general direction of travel is a more open mind towards some kind of assisted dying provisions. But whether we've had enough debate, I think there should be the way the Irish dealt with the absolutely toxic debate about abortion in the Republic of Ireland. They had a citizens' assembly. Now, people can be very cynical about citizens' assemblies, but for an issue like this, it really lends itself.
So is it therefore rushed? Is this the right way of doing it? Should it be? There's an amendment to this bill, which, if chosen by the Speaker, could scupper it, which calls for a review, doesn't it, before the MPs vote?
That may well be the answer. I'll listen to the arguments on that one, but I would certainly think that if this is not resolved this Friday, then I would recommend there be a citizens' assembly, and the citizens' assembly would be a representative group of hundreds of people who are taken through all the detail of all the arguments for perhaps a period of a year, and then reach a conclusion. And that's the way the Republic of Ireland decided to agree to abortion.
Better than opinion polls, which is simply.
Opinion
I don't
polls
think that is a bad
very,
way of doing
very superficial. In an opinion poll, I'd have voted yes.
Yes.
But reading all this stuff
That's the problem.
is a bit more complicated.
Well, it's a big moment in our national life on Friday.
It is. And once done, it will never be undone.
And still no choice by you yet, Sir Bernard Jenkin.
I'm sorry to disappoint you. I will listen to the debate.
We'll wait and see on Friday. Sir Bernard Jenkin, thank you for joining us today on Chopper's Political Podcast. Thank you earlier to Jake Richards, Labour MP for Rother Valley. Thank you for listening wherever you are and watching on YouTube and elsewhere. I tweet at Christopher Hope on X. Are you on Twitter, Bernard Jenkin?
I'm on X. That's what it's called now.
What's your handle?
Bernard Jenkin.
There we are, of course it is. Email me, chopper@gbnews.uk, if you want to get in touch and have any comment on the rather thoughtful, I think, and important topic today on the podcast. If you enjoyed this podcast, please do tell your friends. If you've really enjoyed it, leave us a 5-star rating and a review on Apple Podcasts and Spotify to help other people find this show. Thanks to the great team of colleagues behind this podcast at GB News, Mick Booker, Jeff Marsh, Rebecca Nunes and George McMillan. And most importantly of all, thank you to you for listening. If you want more Chopper in your life, and who doesn't, please catch me during the week on GB News, popping up with regular analysis and stories about politics in Westminster, and at midday when Parliament sits on Wednesdays for PMQs Live with Gloria De Piero. Keep up to date with our best reporting as well on our website, gbnews.com. But until next time, cheerio.